I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the classic case, Church of the Holy Trinity versus United States. This is a U.S. Supreme Court case from 1892 about whether courts should follow the letter of the law or the spirit of the law. Now, for my students, this is a very famous case. It gets a lot of academic attention and things like that. And for a couple of reasons that I want to explain. First, historically, it's very significant. It's an immigration case, but also a religious case, a case about religion and public policy. But it's also maybe the first time, or at least one of the first times, that the US Supreme Court kind of worked around the plain meaning of a statute using the legislative history. So that was not the practice at common law at all. And the Supreme Court sort of out of the blue used the legislative history to get around the plain meaning of the statute. At the time, this was sort of a blip or a historical outlier, but a generation later in the New Deal, the Supreme Court dug up this old case and started citing it a lot for what eventually became the standard practice, which is to rely heavily on the sort of paper trail of the legislative process, those committee reports and floor debates and so forth that Congress produces along the way when they're enacting a statute. And so for a lot of the 20th century, courts relied heavily on those to ascertain the meaning of statutes. And it all sort of starts with this case. That's why it's a famous case for statutory interpretation. It's also a famous case because in our sort of public debates or public discourse about religion in politics or religion in public policy, this is a famous case because at the end of the opinion, the justice writing the majority opinion kind of goes on a little rant about how America is a Christian nation. And so that either makes people really happy or really upset. And so this case is sort of famous for being the Christian nation opinion by the US Supreme Court in the late 1800s. So let's look at what happens in this case. The case starts with a statute. Of course, we're doing this for statutory interpretation. The Alien Contract Labor Act. Now, for my students, this is one of our early anti-immigrant statutes. In the late 1800s, we started passing laws, Congress, to stop immigration and stop companies from bringing in foreign labor or foreign workers. And this was one of the main statutes. And it provided in relevant part that it was a crime to contract with an alien living abroad to come to the United States to, quote, perform labor or service of any kind. And that phrase really matters. Make sure you caught that, to perform labor or service of any kind. Now, Holy Trinity Church, which is still there in New York City, was a prominent church at the time. It's an Episcopal church. And they wanted to bring a famous preacher from England to the United States, Reverend Walpole Warren. And so he was supposed to move from England to New York City to become the parson or lead minister of this congregation. Now, the federal prosecutor in New York actually brought a criminal action against Holy Trinity Church, alleging that their contract violated the act, the Anti-Immigrant Act. And this case is famous today because the court found a way around the unfavorable statutory verbiage and basically says the spirit of the law prevails over the letter of the law. And by the way, the trial court ruled against the church and sided with the prosecutor. This is a news clipping from the time talking about how the court had held that Reverend Warren wasn't going to get to come. Okay, so then we go to the US Supreme Court, and it's Justice Brewer is writing the opinion for the majority. And he begins by basically conceding that the statute is bad for his side. He says that clergy serving in a ministry position for a salary is a type of service, and maybe a type of labor in the broadest sense of the term. So he basically admits that the statute's plain meaning is unfavorable for the church. So how is he going to get around this? Well, wait, it's even worse than that. He goes on, and here's a quote. Not only are the general words labor and service both used, but also, as it were, to guard against any narrow interpretation and emphasize the breadth of meaning, to them is added of any kind. And further, the fifth section, which makes specific exceptions, lists professional actors, artists, lecturers, singers, and domestic servants, and strengthens the idea that every other kind of labor and service was intended to be reached by the first section. And by the way, I have in kind of fine print here a Latin quote. There's a canon of construction we will study in another part of my course that we call the Expressio Unius canon, that basically is the idea that if the legislature delineates some specific things that either apply or that are exceptions or something like that, by doing so, it's supposed to be an exclusive list. And so by mentioning actors, artists, lecturers, and so forth, that would suggest, under this sort of traditional canon of construction from the common law era, that Congress didn't include any other types of exceptions, including ministers or priests. Please note that the court maybe could have stretched the meaning of lecturers or something like that to include preachers, but this is an Episcopal church, so the Reverend Warren was going to be administering sacraments and things like that as well, doing baptisms and weddings and funerals and communion and so on. And so he's really upfront, Justice Brewer, that the statute on its face is really clear and doesn't have an exception for Reverend Warren. And then he says, by the way, this is his little disclaimer, or you might say the court is in denial here. He insists, we're not substituting the will of a judge for that of the legislature. We are not legislating from the bench. This is not judicial activism, even though you better buckle up because we're about to throw the statute out or ignore it. But he says, when we look at the whole legislation and the circumstances surrounding its enactment and the absurd results which follow from giving such a broad meaning to words, it would make it unreasonable to believe that the legislature intended to include the particular act. And for my students, if you're watching this right after my video about the case Riggs v. Palmer, this should sound familiar. This is the common law concept of the absurdity doctrine, that courts are not supposed to interpret statutes to produce absurd results in cases. And one of the ways of packaging the absurdity doctrine is to say the legislature wouldn't have intended that. If we could have asked them, if we had a procedure for certifying questions, we know that they wouldn't want us to do this. And so this idea grounds the absurdity doctrine in legislative intent, which is handy if you really need to not to ignore the words right in front of you on the page. Now, you could also phrase the absurdity doctrine, of course, as a matter of the judiciary's inherent responsibility to administer justice and fairness and to do the right thing and so forth, but that's not the way it's presented here. Okay, let's go back to the case. So despite the apparent clarity of the text, the court invokes the familiar rule that a thing may be within the letter of the statute, yet not within the statute, because not within the spirit or not within the intention of its makers. In other words, we think that you could have an exception that's there kind of in the spirit of the law, even though it's not there in the letter of the law. By the way, this is the letter of the law, spirit of the law is a phrase that comes from the Bible in 2 Corinthians 3:6. And where the Apostle Paul is using it to refer to the Mosaic law. But courts in the common law era had picked this up as a nice phrase for statutory interpretation and talking about legislative purpose versus the verbiage that they actually enacted. So then the majority moves on to three main arguments. And first, they bring out this thing called the Senate report. So as you know, there's a House and a Senate. By the way, the Congress's building, current Capitol building, was under construction probably in the late 1800s still. So the Senate report stated that if there were more time, the committee would propose an amendment adding the word manual and labor to service to clarify. And so the committee said it wasn't going to propose the amendment because it was rushed to get the bill passed during the present session and didn't want any delays. And so this is one of the first times that the Supreme Court of the United States is taking one of these committee reports and from one of the houses of the legislature and giving it a lot of weight and insight into what was going on in the minds of the senators. Of course, most of the Senate's not on that committee that's producing this report. And so there's always a question about how much this represents the whole of the Senate. On the other hand, these reports are full of like details that can fill in a lot of gaps. And so notice that it would have solved this problem if the statute had said you can't bring manual laborers here. And that's exactly what the court basically says the statute was trying to do, is that this was trying to stop the import of agricultural workers and railroad people to build the railroads and construction workers. And so it kind of talks about them as, in very disparaging terms, that these manual laborers come here and they live in poverty and have terrible communities and so forth. And so there was a reason Congress didn't want manual laborers brought here, but they wouldn't have minded having especially clergy or intellectuals or people like that. And if only the statute had had that phrase, it would have ended the case. And now we have a Senate report saying we actually intended to put it in there. We just didn't have time to insert that one word. It's kind of weird, I think, that, of course, I hope you're skeptical. They have time to write a big old paragraph explaining why they can't insert the single word manual in front of labor, but they don't have time to write the one word manual, which is kind of contradictory. So then the majority says, it talks about the title of the bill. The title of the bill refers only to labor and not labor and service, even though the text of the statute talks about both. And so he's inferring from the title that this had a narrower purpose. This continues to be controversial today because the title of the bill is part of what Congress votes on. And so maybe it's part of the enactment itself. It's a little different than other types of legislative history. So that Senate report that he talks about first, it wasn't voted on by the houses of Congress. It's just a report that a committee generated. But the title of the bill is right on the bill that they all have a copy of, that they are, when they call the vote, they're voting on. And so it might have informed how they understood what they were doing. Third, he talks about mischief, and this is a common law doctrine, again, of interpretation called the mischief rule. When the mischief rule, the idea is, look at if there was legislation, if Parliament or Congress passed a statute, there must have been a problem they were trying to solve, right? And a breakdown in the common law system, or a social problem that couldn't just be settled by the courts in our existing laws. There was some reason we needed a whole new law to deal with this problem. And so the mischief rule says a great tool of statutory interpretation is to look at the mischief. What was the problem that prompted the enactment of a whole new law to address it? And so what's the mischief here? He applies a mischief rule and said it was the influx of cheap manual labor. And he describes them again in very disparaging, maybe bigoted ways, to work in the nation's mines and factories and railroads and things like that. And then we get to the third part, and this is the Christian nation quote, which I have here shared for you, pulled from an internet meme. These and many other matters which might be noticed add a volume of unofficial declarations to the mass of organic utterances that this is a Christian nation. And the court relied on separate grounds specific to the bill's application to a cleric, the idea that no purpose of action against religion can be imputed to any legislation, state or national, because this is a religious people. Now, the way this is brought out today is to argue basically that we should have more religion in politics, and that America should get back to its Christian roots, and so forth. But I want to offer a moderate view here in favor of what Justice Brewer said, and that is the idea that this could really raise some constitutional questions under the First Amendment. And he doesn't really articulate the idea of constitutional avoidance, but that's one way to interpret his Christian nation speech. It's not just, look, it's a Christian nation, and so obviously we're not going to hold this against Christian ministers, but his idea that we do have a constitutional amendment protecting the free exercise of religion, and that could really complicate our assumptions about whether Congress intended to ban foreign clergy from getting to come here and perform services for religious groups. And so even if you don't like the way Justice Brewer expresses this, there is something valid there about that this was really a First Amendment minefield for the court that they were trying to sidestep and find an interpretation that didn't create free exercise of religion problems. The court said that the US is a religious nation, so it made no sense to assume that Congress would have applied the statute to clergy if it had come explicitly to its attention. And they asked, can it be believed that it would have received a minute of approving thought or a single vote? And honestly, at the time in the 1800s, probably not. He's probably right that Congress would not have considered banning foreign clergy from traveling here to preach in a church. Also note that in the 1800s, we're here talking about the use of legislative history. The court almost never relied on legislative history. In fact, they frequently stated that there was kind of an unofficial rule against it. So this case was really a bit of a path breaker. And as I said in my introduction, a generation later in the New Deal, the court cites this case, Church of the Holy Trinity, very frequently to justify using legislative history very frequently. And in fact, just for my students to know, in the common law era in England, there was actually a strict rule against courts using parliamentary history. So this idea of relying on legislative history is really came into prominence and became the prevailing practice only in the 20th century, or for Gen Zers, the 1900s. And they based that on this case from the late 1800s. Okay, let's talk a little bit about these reports just to make sure you're clear on this. If committees are crucial gatekeepers and devote disproportionate effort to studying and framing the legislation, should interpreters give special weight to the committee's expressed views? And in the later generations, the Supreme Court basically says exactly that when a bill is proposed in Congress, it goes to a committee that specializes in that area. So if it's an energy bill, it goes to that committee. If it's a tax bill, it goes to the Ways and Means Committee, and so forth. And so they're very familiar with the existing laws, and they're the ones who really double down on it and edit and revise the wording and debate about every word in the statute that's going to go to the floor and so forth. So maybe we should give a lot of weight to them because the committee are the ones who spent the most time thinking about this. But on the other hand, there might be a danger that the committees are not representative of the views of Congress as a whole. Remember, it's just a few people on this committee. And even though the rest of the Congress usually defers to the committee reports, we're not sure the rest of Congress even reads them, and they certainly don't vote on them. And we'll get to that later. So despite what the committee report says, by the way, about how they didn't have time to change the bill and go to the floor with the amendment to add the word manual, it actually didn't even pass in that session anyway. The committee, in fact, had plenty of time to introduce a desired amendment because the bill was reintroduced and passed in the next session of Congress. So this line that the court relies on from the Senate report is historically dubious. The bill's managers probably just thought that if they put the word manual labor in, they wouldn't get the votes to pass the bill because it would narrow the scope of the statute. And there were people who really wanted it to be a broad anti-immigration statute. Okay, here's a review question to see if you've been paying attention. Which of the following better describes what the court did in the Church of the Holy Trinity case? A, it held the statute was unconstitutional for violating the free exercise clause, like religious liberty. Or B, it held that the true legislative intent was different than what the statutory verbiage suggested on its face. Hopefully you know the answer. If you don't, you weren't paying attention and you should rewatch the video. And that concludes our quick lecture on the Church of the Holy Trinity case.